Hello everyone, welcome to the second lecture in the research component of RWA. In this lecture we will be talking about statutes and administrative regulations. Before we launch into the branches of government, I want you all to know that it's okay if you don't remember all of this. I recognize that some of you were poli-sci majors and this is all elementary to you. However, not everyone focused on this, or not everyone may remember all of this, so we're just going to go through some basics of how the United States government is structured. Please don't hesitate to come see me if you want to discuss any of this further. No questions dumb, and I swear no judgment will be passed. So, there are three branches of the federal government: the executive, the judicial, and the legislative. This class we will focus on the legislative and the executive branches. Next week we'll discuss the judicial branch and case law. As we progress through the research component, you'll see that our legal system is quite complicated, and there are a series of checks and balances throughout. Understanding how these branches work together is key to being able to research effectively and know that what you found is the law that actually applies to your problem. The executive branch consists of the president and administrative agencies. The president has the power to veto legislation coming out of Congress. In addition, the president has the responsibility of enforcing the laws that come out of Congress. He or she is the final signature on each law and takes the job of enforcer. In order to enforce these laws, the president tasks a myriad of administrative agencies with enforcing these laws. Now, administrative agencies are created by statute. Wait, what? Yeah, so agencies get their authority from the statutes passed by Congress, but agencies are still considered part of the executive branch because they actually enforce the law. The legislative branch is Congress. We're going to talk solely about the United States government and not about individual state government, just to keep things simple. The U.S. Congress is bicameral, which means that there are two houses, the Senate and the House of Representatives. There are 535 voting members in total, 435 in the House and 100 in the Senate. Each Congress covers 2 years, and each year is a session. So we're currently in the 115th Congress, and we are in the first session of the 115th Congress. In January 2018, the second session of the 115th Congress will begin. Again, if you have any questions, just keep track of them. I do plan to discuss this in class because it can get kind of confusing. So it all starts with an idea for a bill. This could be in response to something that happened or maybe just a proactive measure. To simplify things, we're going to start this bill in the House. That bill is then sent to a House committee and then sent to the House for approval. The House will then send the bill to the Senate, and the Senate will send that bill to a Senate committee, and then once approved, we'll send that bill to the whole of the Senate to be approved. Once the Senate approves an identical form of the bill as the House did, the bill will then be sent to the President. The President may then sign the bill or veto the bill. If the bill is signed, the bill then becomes a public law and is assigned a PL number. It will then be placed in the statutes at large, and then eventually it will appear in the United States Code. So I understand this is a very simplistic rendering of the process, but I think it gives you a good idea of everything that goes into the process. So now that we have a basic understanding of this, let's talk about statutes and statutory law. I think statutes can be frequently overlooked, and they're probably the best source of the law. A lot of questions can be answered by simply checking to see if a statute exists. U.S. law is dominated by statutory law, but that just doesn't seem as glamorous as case law. I don't know if it's the lack of a flashy storyline, but statutory law is very important and shouldn't be overlooked. I'm only going to focus on this process again from the federal level to keep things simple. There's a basic pattern of statutory publication. When a law is initially passed, it is published as a slip law. This is a really limited form of publication. It's then published again in the statutes at large, and these are a historical record of all the laws passed. They can also be referred to as session laws. I'd make note of this because the term session law and statutes at large are terms that are used interchangeably. The laws are then broken down by topic and published in a code. In the case of federal laws, the United States Code. Slip law and session law versions should be identical. So what if they're not? When would you want to look at a session law? I've provided a link to a blog post from the Law Library of Congress that discusses the difference between the U.S. Code and the statutes at large and when you would use one over the other. Each of these phases of statutory publication has its own citation format. You may ask why you even need to know this. Like, who cares what the public law number is or the statute at large citation? Well, you care, or at least you'll care at some point. If you do any research into legislative history, and you will, it is important to know these citations so you can locate important information related to the development or evolution of the law. If you're trying to interpret a statute for a client, say you're trying to figure out what the intent of the statute is, knowing the history behind the enactment of the law could be beneficial and could be used to sway the judge. Also, sometimes you have to find out what the law used to be. That is, the law may have been amended, but you need to know what the law was 5 or 6 years ago. You may have to dig through these citations to find what the law used to be, and that may or may not be available to you at the click of a button. A code is an arrangement of statutes currently in effect by topic. So instead of having books of statutes as they are enacted, these are divided up by topic to make them easier to navigate. With each update, repealed statutes are pulled and revisions are made. So, why should you know about the statutes at large when you have this great code? Well, because if you're looking for a prior version of a statute, the only place you may find the prior version is in the statutes at large. So if a change is made, the most recent code will only show you what is currently in effect. You're going to have to do some digging to find out what the law used to be. Keep in mind, when you look in Westlaw or Lexis, you're looking at the law as it currently stands. You may need to use other resources like Hein Online, the statutes at large, or prior print editions of the code to find the prior version of the law. There are really two different types of codes from a high-level view. They are unannotated codes and annotated codes. Unannotated codes are going to be what you find on the free government website. What unannotated means is that it doesn't come with extra research information. That is, it will not refer you to cases or secondary sources that may help explain the law to you. An annotated code reproduces the original text of the code, but adds in information like cases and administrative decisions, attorney general opinions, legislative history, and secondary sources. Some would consider an annotated code to be the gold standard of legal research. Please note, anytime you access Westlaw or Lexis, you are accessing an annotated code. This does not discount the value at all. Just know that if you find an error or are concerned that the wording doesn't look right, you should access an unannotated official code to verify the language of the law. With a statute in hand, your research process may look a bit different than the process you would use when you know nothing about a topic. Again, these steps should just be used as a guide if you lose your way or aren't sure where to go next. It's not lost on me that updating the pocket parts and pamphlets may sound antiquated as electronic resources surpass print resources. However, you still need to be aware of what these things are. You may end up encountering them at some point in your externships, internships, or jobs. Now we're going to turn our attention to administrative regulations. Administrative regulations come from agencies. There are agencies at both the state and federal levels, and overlap frequently occurs. Agencies are tasked with administering programs, regulating the conduct of individuals and businesses, and ensuring public safety. So who issues these regulations? Who are these groups? Well, examples you may be familiar with include the United States Department of Agriculture, or the USDA, the Equal Employment Opportunity Commission, the United States Environmental Protection Agency, and the FCC, just to name a few. As I mentioned before, agencies receive their authority from Congress. The Administrative Procedure Act divides agency action into two groups. rulemaking, and adjudicative. I'm going to discuss the rulemaking function mostly and then briefly discuss the adjudicative function. Agencies serve a quasi-legislative function in that they issue regulations or rules that must be followed by individuals in industry. These are meant to help guide the enforcement of the statutes passed by the legislative branch of the government. These rules are adopted through what is called notice and comment rulemaking. There are books written on this process, so I'm just going to explain it here briefly. The agency creates the rules and then must publish them for public comment. The public is then given a period of time to comment, and then the agency must consider these comments before issuing the final rule. Sometimes the agency modifies the rule, sometimes they disregard the rule completely, and other times they issue the rules as they were originally published. What I find fascinating about the process, though, is that the public gets an opportunity for their voices to be heard. So how do statutes and regulations function together? Statutes come from the legislative branch. That is, they are passed by Congress. In the statute, Congress grants the agency authority to enforce the statute and issue regulations to aid that enforcement. If you think about it, this should make sense. Who's in Congress? Frequently, it's politicians and lawyers. They're the idea people. They may know that the environment is important and needs protecting, and they may be able to come up with and pass a law to help that happen, but they're typically not scientists or engineers or economists, so they leave it to agencies to fill in the blanks and then to assist and enforce. So this is an example of what's called an enabling statute. This shows where Congress specifically delegated authority to the United States Department of Agriculture to craft rules and regulations to enforce this specific statute. Sometimes this authority is clearly indicated, other times it won't be so obvious. But it's important to note that the agency cannot act without authorization from Congress. Okay, so where do you go to find these rules and regulations? The Federal Register is a publication of the United States Government Publication Office, or the USGPO. The Federal Register serves as a type of diary or chronological account of the happenings within federal agencies. There's also different information like presidential documents and other notices. The Federal Register serves a few purposes. As a diary, it provides the past and present activities of an agency. It also provides future deadlines for the notice and comment period or for when a regulation may take effect. It can also serve as a research tool in that it can provide reasoning behind a final regulation or give insight into why changes to a regulation were made. You can locate the Federal Register online or in print in federal repository libraries. Westlaw and Lexis also provide access. I like to note that important information related to specific agencies can sometimes be located on the agencies.gov websites as well. Now, think of how difficult it might be to find a regulation if you don't know the exact day the final rule was issued. This is where the Code of Federal Regulations, or the CFR, comes into play. It serves as a resource organized by topic of all agency rules and regulations currently in force. Here's just a list of places where you can find the CFR. You can pay for it, you can use the paid databases, or you can also find it free online. This is just an example of a page from the CFR. The first circle tells you the enabling statute, that is where the agency was granted the authority to issue the regulation. And then the second circle shows which act these regulations are related to. Finally, this circle shows where within the Federal Register this was initially published. Now, I mentioned earlier that agencies also serve an adjudicative function. For the purposes of this class, it's enough that you know that agencies hear cases typically specific to individuals. The opinions issued by the administrative law judges typically have no precedential value, but can sometimes be persuasive if they're taking a case before another administrative law judge. We've now finished our second lecture. If you have any questions or concerns, please don't hesitate to contact me. I'll see you in class.